Hi everyone, I'm just doing a quick video to update everyone on the goings-on in Maine regarding Assistant District Attorney Mary Kellett. For those of you who don't know, she works in the DA's office in Bar Harbor, and her per capita prosecution rate for domestic violence and sex crimes is about 40 times higher than the general population of prosecutors in the U.S. She was brought to the attention of National Coalition for Men and A Voice for Men by Vladek Filler's case, a man repeatedly prosecuted or persecuted by Kellett on essentially zero evidence for spousal violence against his immigrant wife, Lygia. Now, a little about Lygia. She is mentally unstable, has a history of criminal acts, and a history of violent abuse of her children. This is in fact why Vladek had filed for divorce in 2007. Arrested shortly thereafter while wandering half-dressed, drunk, and ranting in the street, Lygia was recorded by one of the arresting officers threatening to kill her husband and to kill the officers themselves, claiming she would dismember their bodies and disappear them with the assistance of her relatives. Now, it was at this point that the Fillers found themselves in the path of Mary Kellett, not over any kind of justifiable prosecution of Lygia for public drunkenness, indecent exposure, or uttering threats, but over a charge, an accusation of spousal rape against Vladek Filler made by Lygia. Now, Lygia's behavior, especially toward her husband and children, has been so egregious and erratic that even after that first charge against Vladek was filed, a family court judge not only granted him custody of the children on the recommendation of the Maine Department of Health and Human Services, but Vladek was granted a restraining order against Lygia to protect himself and the children from her abuse. So, I think y'all gotta realize just how toxic a woman's gotta be for this to be the outcome in a U.S. family court after a spousal rape, and domestic violence charge has been filed against the man. So, Kellett conducted a prosecution of spousal violence, rape, and domestic violence against Filler despite no evidence, despite Lygia's refusal to get a rape kit done after making her accusation, and despite the allegation emerging from an obviously mentally disturbed woman during a highly charged marital breakup. The case, oddly enough, ended in conviction, but defense attorney Daniel Pileggi filed a motion for a mistrial, citing several incidences of prosecutorial misconduct, including the concealment of exculpatory evidence on the part of Kellett, and Filler was granted a second trial. In response, Kellett filed an appeal to the Supreme Court of Maine to overturn the decision, quash the new trial, and uphold the conviction. She really seemed to have a hard-on for this guy. Filler's attorney in that proceeding, Neil Fishman, described it as a Salem witch trial wherein Kellett repeatedly misrepresented motions she'd made at the earlier trial, contradicted herself several times, and blamed Filler's defense lawyer, saying he should have introduced evidence of Lygia's motives in making the accusations, despite the fact that she had made motions to exclude that evidence, and those motions had been granted. During this proceeding, Kellett attempted to have the Supreme Court set a precedent that would exclude from spousal assault cases any evidence of the accuser's possible motives to lie, such as a bitter custody battle or a contentious divorce case. Well, she didn't get what she wanted out of that. Not only did the Supreme Court set precedent upholding the rights of accused men to present such evidence, the court found that Prosecutor Kellett had improperly encouraged the jury to use absence of evidence she had herself excluded, to convict, and cited a number of instances in which she had engaged in misconduct, so the order for retrial was upheld. Now, this is when NCFM and SAVE, Stop Abusive and Violent Environments, and A Voice for Men started really covering this case. And all three organizations, among other groups and individuals, filed complaints of prosecutorial misconduct on the part of Kellett with the Governor of Maine and the Maine Board of Overseers of the Bar. In response to all of this coverage in the alternative media, Kellett attempted to get a gag order placed on A Voice for Men and others regarding the Filler case, an attempt that a judge rightly refused to grant. Now, Kellett, who is absolutely not on anything remotely resembling a witch hunt or a personal vendetta, had her own assistant placed on the new prosecution team, despite ever-growing media attention and several formal complaints of her own misconduct and calls for disciplinary action against her, specifically in regard to her targeting of this particular man. Now, Filler was acquitted in this second trial on sexual assault charges, but he was convicted on a single charge of minor spousal assault for pushing Lygia. Now, the evidence for that was a photograph of a single bruise. And this is a bruise that police claim did not exist on her arm days after she said Filler had put it there. This was something that was noted by police in their report of her attempted abduction of one of their children. But the photograph was entered into evidence, the jury bought it, and Filler was convicted of that one minor charge. Now, prior to the conclusion of that case, a hearing was scheduled by the Board of Overseers of the Bar to determine whether Kellett should be disciplined for prosecutorial misconduct. And the system circled the wagons, including assigning Assistant Attorney General Ronald Lupton to defend Kellett. Filler was sentenced to 21 days in jail on the charge of pushing Lygia, and in a bid to prove her lack of prosecutorial bias and her proper conduct as an officer of the court, Kellett arranged to delay his incarceration so that it would run concurrent with her hearing before the overseers. Filler was lucky enough to be allowed to testify against Kellett despite being incarcerated, but was forced to do so while dressed in prison orange and shackled at the wrist. 60 days after the hearing, the findings were released. Kellett had failed to turn over at least 2 key pieces of exculpatory evidence, including Lygia's 911 call in which she claimed that he had raped her, and others including witness testimony, that she had engaged in multiple violations of rules and court orders. She had filed motions that should not have been granted. She had misled the jury by claiming that the lack of exculpatory evidence for Filler was evidence of his guilt, even though it was Kellett who had appealed to the judge to exclude that evidence, and that she had engaged in conduct unworthy of an attorney. Now, knowing attorneys, I figure the bar is set pretty low on that one. The state bar panel recommended that she be suspended until a disciplinary proceeding could be scheduled. But the Attorney General of Maine and the DA's office of Bar Harbor have taken no such action. She has remained free in the interim to prosecute crimes in Bar Harbor. Talk about circling the wagons. And here's a news story that I got off of YouTube of just what that case was all about and how some people involved in the Attorney General's office and in district attorneys' offices are spinning it.
The Board of Overseers of the Maine Bar says for the first time ever is recommending a prosecutor's license to practice law be suspended. The panel found Hancock County Assistant District Attorney Mary Kellett in violation of ethical standards. Among the violations, engaging in conduct unworthy of an attorney. News Center Samantha Edwards joins us now with details. Samantha?
Thanks, Chris. This review stems from a 2009 case where Kellett prosecuted a man on charges of rape against his wife. The man was acquitted and filed a complaint that Kellett did violate bar rules during her prosecution. Now, the man argues Kellett did not have probable cause or enough evidence in her case against him. A 3-person panel spent 2 days reviewing the evidence of the case against the Hancock County ADA. Prior to the hearing, Kellett held a clean record and cooperated with the board throughout its investigation. But one group, Stop Abusive and Violent Environments, spent the last year highlighting Kellett's actions and pushing for the state to take action.
This was a pattern of misconduct that occurred over a period of months and even years that involved Mary Kellett and other people in that same office of prosecutors in District 7 of the state. So this was not just a one-time incident or because prosecutors were overworked. This is really a problem of a pattern of a systemic prosecutorial misconduct that was documented not just in this one case.
Mary Kellett, from my personal knowledge of her, I know her to be a very dedicated, hardworking prosecutor trying to do the best she can for her community. On the other hand, we have a group of individuals who are making judgment on her conduct, and with all due respect to them, I'm not sure they really understand the pressure that she's under and some of the obligations that we're under, and so then they make a judgment against her. It's disheartening for all of us.
The board did find 2 points of concern through its investigation. First, Kellett's rebuttal during the trial highlighted the absence of evidence and caused prejudice toward the defendant. This was evidence that she had argued to keep out of the trial. An expert on the panel described this move as stubborn and that she appeared to be bucking the court during her rebuttal. The second point found Kellett withheld 2 key pieces of evidence from the defense. The evidence was the 911 recording from the night of the alleged rape and some witness statements. Members of the panel say the seriousness of this issue cannot be overstated, and that it was Kellett's ethical obligation to produce the evidence. Kellett argues she and her colleagues did not find the evidence important to the defense's case. These findings are what led to the panel's decision to recommend suspension. It's a decision Penobscot County District Attorney Chris Almy is concerned by.
It's a difficult situation, but for not just Mary Kellett, but for all prosecutors, because this decision that they make reflects on how we're supposed to do our job, and I'm not sure that they've got it right.
Chris Almy says the suspension of Kellett would add strain to an already short staff and heavy workload. But her suspension is by no means a certainty. Kellett will appear before a justice of the Supreme Judicial Court. That justice will then make that decision. We did try to speak with the Hancock DA's office and Kellett herself, but neither were available for a comment. Chris, back to you.
Okay, thanks very much for that report, Samantha.
Now, through all of this bullshit, from Vladek's filing for divorce in 2007, the children have been in either his custody or, when he's been behind bars, in the custody of the foster care system. Ligeia has made several attempts to claim custody of the children, from applying through the courts to showing up where they're staying and demanding they be handed over to her, to attempted abductions. Ligeia was caught on police video in during the investigation of the initial charges, telling a friend subsequent to that case that she was fighting for the children and receiving advice to cry more to be more believable. Ligeia has a family court documented history of verbal and physical abuse of both the children and her husband, a history that has kept the children not only out of her custody, but has resulted in a restraining order against her. To my knowledge, Ligeia has not been charged with any crime related to this case. Now, John the Other has speculated that Kellett is being incentivized by provisions in the Violence Against Women Act to maliciously prosecute potentially innocent men for monetary gain. And yes, VAWA does provide financial and immigration incentives to individual women who make accusations of domestic violence or spousal rape, as well as financial incentives to district attorneys' offices to bring such cases to trial. But these incentives exist, whether a case ends in conviction or not. Kellett's office gets its money, whether these men are convicted or acquitted. The money doesn't explain why Kellett is so determined to see Filler in prison that she would conceal exculpatory evidence, file motions to exclude evidence of the accuser's motive or state of mind, instruct the police to destroy videotapes rather than hand them over to the defense as per a court order, or lie outright to the Supreme Court. Her prosecution rate, specifically for domestic violence and sexual assault, is again 40 times higher per capita than one would expect. In addition to that, she was overheard in the courtroom at the first trial, while the jury was not present, joking and laughing about Mr. Filler running to call his mommy when his wife had punched him in the face, and making racist remarks about how men of Filler's ethnicity always abuse their women, and Filler's sons would be raised by him to be abusers. She doesn't sound anything like Kathy Brennan of Radical Hub, does she? This is not about the oodles of VAWA money for Mary Kellett. The VAWA money just gives her the funding she needs to do what she really wants to do, to lock men up and to excuse violent and psychotic women. This is all about the sisterhood, and Kellett seems perfectly prepared to cast the entire criminal justice system of Maine into disrepute to serve her ideological, bigoted, and hate-based beliefs. Now, the decision of the overseer's hearing, right? The panel recommended that she be disciplined, and so there needs to be another hearing, one to decide what, if any, punishment Mary Kellett should be subject to. And so the system is left with an unanswered question. What are we going to do about her? The investigation into her conduct and the overseer's hearing indicates something does need to be done, and a disciplinary hearing has been announced to decide exactly what, with 1 week's notice. That's right, July 15th in Portland, Maine, 3 hours' drive from the people of Bar Harbor, who have the greatest vested interest in the outcome of this case. Now, we're assuming the timing and the short notice are an attempt to have as few interested parties in the courtroom as possible and as little media coverage as they could get. And I would assume that since there is so little notice and so little time for either side to prepare, that maybe there's been some kind of backroom deal already made. Some kind of plea agreement that will give Mary Kellett license to continue to act as a prosecutor in Bar Harbor. And that's why we are asking, A Voice for Men is asking if any one of you guys, any one of my viewers who happens to be in the vicinity of Portland, Maine, and might want to engage in some citizen journalism, to please contact John the Other, that's John Hambling, at john@avoiceformen.com. Even if the mainstream doesn't give a whole lot of fucks about this case, or this prosecutor, A Voice for Men sure does, and we want to know exactly what goes on in that room on the 15th. So, any of you guys want to do this, any of you guys are available to do this, please let John know. I'm going to leave the link to his email in the low bar, and hopefully we can get some people in that courtroom seeing just what goes down. And I don't hold out a lot of hope, given what that one district attorney in that news story had to say. I think that they're going to want this to just go away. They aren't going to want to have to admit that there's anything punishable going on in their system, because any one of them could be next. And I think that this is just the case of something that's been going on under the radar for a long time, and you have one loose cannon who doesn't care whether she's above the radar, and I think that they're actually going to really try and protect her and really try and sweep this under the rug. So, again, anyone who possibly can attend this hearing, please contact John, and he'll make arrangements for, coordinate and try and figure out what exactly needs to be done and what's allowed and what's not. So, anyhow, that's it for me for now, and I will see you in another couple of days. I owe National Coalition for Men a video in a very good cause, and so I will be uploading that in the next couple of days.